SJC-11764, Kevin Bridgeman and others v. District Attorney for Suffolk County and others.
Thank you.
Good morning, Mr. Siegel.
Good morning, Mr. Chief Justice, and may it please the Court. With me at council table is Ben Keene, who will be arguing for CPCS. And this is Matthew Siegel for the petitioners. Thousands of people whose rights were violated by misconduct at the Hinton Lab will have no meaningful opportunity to challenge their convictions unless this court caps their exposure and prevents further delay.
Why?
Those remedies, Your Honor, are not only fair.
I'm sorry, what?
Those remedies are the fair response to the situation that has emerged since this court's decision in Scott. Scott governs what happens.
People apply for, they file a motion for a new trial, they get a hearing, they get a presumption of egregious misconduct.
That's right, Your Honor. And so the reason why we're here today is that Scott governs what happens inside the courthouse doors. Yeah. And yet, at the same time, there are thousands of people who have not been advised properly on how to reach the courthouse doors, and the ones who have been advised are afraid, for good reason, to knock. And the reason they're afraid, Your Honor, goes to not just the fairness of the remedies we're requesting, but that they align with two constitutional principles. The first is that notwithstanding the rough and tumble of pre-conviction plea negotiations, the law is clear that defendants seeking post-conviction relief must be freed of apprehension that doing so will trigger retaliation. Yet the Hinton Lab defendants, the vast majority of whom have already served out their sentences, have good reason to be afraid. They reasonably surmise that given the scope of this scandal, prosecutors need to keep the floodgates closed.
Does that same reasoning apply when a defendant who has pleaded guilty seeks to have the guilty plea set aside because of ineffective assistance of counsel?
It does not, Your Honor, not in the typical case. And the reason has to do not just with the sheer volume of these cases, but also with the reasons that the reason why people are challenging their convictions isn't a normal mistake in the process, but instead government misconduct. So I want to address both of those aspects of this. The first, with respect to the floodgates, no one before this court is saying that they could handle all of the cases that could reasonably be challenged. What the district attorneys have said is that they can handle, they have managed the 1,100 or so motions that have been filed. That's the tip of the iceberg.
And how much of a backlog is there? 70 cases have been unresolved, at least as of the time of their filing?
That's right, Your Honor. The trickle has run dry for the reasons we have identified. The fear and the fact that thousands of people haven't been advised about their rights. It would be the same to say in Lavallee, Your Honor, that, well, Mr. Lavallee hasn't yet filed anything in his case. I mean, the case was brought because he hadn't been assigned counsel.
Lavallee is a much smaller matter here and a very different set of
That's right, and that goes back to Justice Spina's question about how the volume affects. No one in this case is telling the court that they can capably navigate the entire iceberg. Everyone is saying that the tip, the 1,100, has been capably navigated.
And so why? And you're saying nobody else is filing because they're afraid?
They are afraid, and one reason why they're afraid.
Don't know.
Well, there is the group that hasn't been advised of their rights at all, which included.
How big a group is that? How big a group is that?
Well, Mr. Keene will be better able to answer that question, but my understanding is there have been only 8,700 or so assignments of counsel, and of those, only a much smaller number of attorneys have actually had an opportunity to meet and confer with potential clients.
And given the report, there are roughly 40,000?
Well, it depends on how you estimate. Just to be conservative, we could say that, let's say that only 20,000, I say only 20,000, of those resulted in conviction. Even so, we're talking about less than half of the people who've actually been assigned counsel.
But how many people are not afraid and are totally satisfied with the result they got the first time around?
Well, I don't know the precise answer to that question, but I can tell you, Justice Spina, a line that could be drawn there is that the people who had something, who had still time left on their sentences, were able to negotiate for, say, time served pleas. They might be happier. But if you look, Your Honor, at someone like our client, Mr. Cuevas, he pled guilty in 2009 to several drug offenses. By the end of 2009, with Mr. Cuevas in prison, people in the Hinton lab started to raise concerns about Ms. Ducan's conduct. By June 2011...
But it still strikes me, though, that your assumption is that however great the number is, 40,000, that all 40,000 of these people are afraid to come forward. Is that... What's the basis for saying that?
Your Honor, that is not my assumption. It's not my assertion at all. What I'm saying is that there's essentially two key populations here. There are people who have just not been assigned counsel, not been advised of rights. I don't assume that they have any view on the exposure issue. They might not have a view on, they might not even know that they can challenge their convictions, let alone be afraid to do so. But there are people, and there's evidence in the record to this effect. There's what has happened in Mr. Cuevas's case, where the Commonwealth, as Nancy Kaplan's letter that we submitted, where there are probably points out, there are prosecutors who are saying in Essex County, if you challenge your conviction, we're bringing everything back. And there are prosecutors saying in Essex County, if you challenge your conviction, we are withdrawing plea offers that are on the table at present. That means that defendants can reasonably infer that whether they pursue post-conviction relief will determine the prosecutor's response.
So your client is who here? Your client is who?
Our clients are Mr. Cuevas, Mr. Bridgeman, and Mr. Creech.
So Mr. Cuevas has been threatened.
He has been told...
that if he succeeds in withdrawing his plea, and that's an open question, he's going to have to demonstrate that he wouldn't have entered into it. If he succeeds, that he will be prosecuted for additional crimes and punished more, and they will recommend more severe punishment.
I don't know the full extent of it. I'm sure the district attorneys will stand up in a moment. I'm sure they can say precisely.
Just asking your client. This is your client.
Our understanding, based on statements in open court, is that the district attorney's position is that if he succeeds in challenging his conviction, the entire case will come back and he'll be prosecuted.
Well, that's true. It does come back legally.
Well,
springs back.
Our submission, Justice Cordy, is that legally it absolutely does not. And that's because not only of the threat of prosecution, but because of the remedy for the misconduct. And the case that is the best on this, Your Honor, is Judge Wolf's decision in the Ferrara case. There, the government made precisely the same argument that you're paraphrasing, Justice Cordy. It was when the defendant challenged his plea, the government said, well, in that case, the plea agreement's off, and we're going to bring back in conduct that we relinquished as part of the plea agreement. And the conduct there was murder. They said, we're going to ask that the judge hold you responsible for a murder for which you were granted immunity as a part of the plea agreement. Judge Wolf said, no way. He wrote, it would certainly be inequitable, if not unlawful, for this court to find that Ferrara has lost the immunity provided in his plea agreement because the government violated his constitutional rights. That's a hard cap. And it's the same hard cap we're requesting here, with the difference that we have additional arguments in support. Judge Wolf was providing that merely as a remedy for the misconduct that had occurred in that case.
And that's why I'm a bit perplexed while you're arguing vindictiveness, which arguably is a broader argument than the narrower supervisory authority that was argued in the amicus by Ropes and Gray. I mean, that we have a whole lot of cases where immigration advice is a source of motions for new trial, and one could say there's going to be a flood of motions. There already is, I'm sure, a flood of motions for new trial based on that. But your argument would say that the vindictiveness argument would apply to them too. even though there was no egregious government conduct that was the source of those motions for new trial?
We certainly agree, Mr. Chief Justice, that you don't need to get into prosecutorial vindictiveness. You could certainly order the relief we're requesting merely as an exercise of the supervisory powers of this court as a remedy for the misconduct that the court has already recognized. But it's important, we think, in fashioning a remedy to consider the exposure issue. And again, we're not alleging actual vindictiveness. What we are saying is that defendants have reason to be apprehensive, and they have reason also to be concerned about the timing. And this goes back to the Cuevas hypothetical, or not hypothetical, reality. I mean, he served out his sentence while the Department of Public Health was deciding whether to disclose Ms. Ducan's fraud. By the time they did that in late August, September of 2012, see that my time is up, may I continue? He was nearly done with his sentence by the time the Department of Public Health made this public. And then when he moved to stay his sentence, the last remaining bits of his sentence, the district attorney opposed it. And so now the only way that he can seek any meaningful relief is if he understands that doing that will not yield him more time. And that's why we raise the issue of vindictiveness, not to accuse the district attorneys of additional wrongdoing, but to say that this is so vital to the resolution of this crisis. I mean, imagine if in 2012, when this scandal hit, the announcement from all parts of government hadn't been, let's roll up our sleeves and fix this crisis, which lots of people have tried to do, but instead, don't worry about it. Because in time, few people will actually be told about their rights, and the ones who are told are just going to be too afraid. And that wouldn't be a resolution to this problem, Your Honor.
Thank you.
Thank you.
May it please the Court, Benjamin Keene on behalf of the Committee for Public Counsel Services, and with me is Attorney Nancy Kaplan, also from the Committee for Public Counsel. I want to address the numbers issue, and then, which I think is also relevant to CPCS's legitimate right to be here today, that is to say our motion to intervene.
And when you address that, would you define what you mean when you call people a Ducan defendant?
Yes, a Ducan defendant is a person, either identified or as yet unidentified, who, if he or she had the advice of counsel, would, assuming he or she was not chilled from doing so, would be able to establish the first prong under Scott. That is to say that he or she pleaded guilty or was found guilty on the basis of egregious government misconduct, to wit, the ability to show the court a drug certificate allegedly claiming that the evidence used to convict the defendant of the drug offense was signed by Annie Ducan. Those are the 440,232 names that
I'm sorry, signed by her as primary or secondary, not signed by her as a notary.
Right, we're just claiming
The
primary or
40,000 are
secondary.
just primary and secondary, or does
Correct.
it include also notarizations?
It does not. My understanding is it does not. So,
And we know there are 40,000 who were found guilty?
no.
Exactly.
Now, here's the problem. We're 2.5 years out from this, and we are virtually no closer than we were when the scandal broke to actually being able to provide relief for all of those who have had their rights violated.
Who has
And
the
this-
necessary information, Mr. Keene?
The district attorneys. If you look at page 348 of the record appendix, that is attachment D to the David Meyer report, in which he did an unbelievable job of assembling the mess of the Hinton lab data into a usable form. Attachment B is a mock-up that he prepared for illustrative purposes of what the so-called Meyer list looks like. And the final field of that list is labeled drug submission form, click for drug receipt. If you turn to the Meyer report itself, particularly page 340, Yeah, 340.
Is that 340 of the Meyer report?
No, I'm sorry, 340 of the record appendix, page 13 of the Meyer report. The drug submission form, which he's talking about, that last field, contains additional confidential law enforcement data and information which should enable the district attorneys and/or their respective law enforcement agencies to locate the applicable police reports, arrest booking records, and any other related materials. Police reports and related materials, that's the holy grail for anyone who's truly interested in identifying a Dukin defendant, and that's what, until we sought to intervene in this case, none of the district attorneys had seen fit to assist CPCS in accessing. We, as a general matter, will have in the Boston Police Department parlance, have in the file a CC number, a police report number. But we don't open cases with that data. We can't find cases via a CC number. They can. And that data links to a complaint in a district court case, i.e. a docket number, i.e. a defendant. Once we get those docket numbers, which we still don't have a list of, we can look to see if they were in fact convicted by virtue of Dukin's misconduct.
So what order specifically are you asking us to make?
Well, on remand, I would anticipate that the parties to this suit will continue to, as they say, voluntarily provide this information that has been belatedly forthcoming.
But the parties to this suit don't include every DA in the state.
No, but this court has ample supervisory authority to make clear that the DAs of the 6 other affected counties should do the same.
And we should do what?
What's that?
And we should do what specifically?
Order them to do what Suffolk and Essex have now belatedly done, which is to link their Meyer list data to docket numbers so that those docket numbers can be searched with the assistance of the trial court to give us reliable identifying information, and ultimately, the holiest of holy grails, disposition data. Did this result in a conviction? Here we are, we don't know. It could be 40,000 conviction, 30, 20, but...
Have this data from Essex and Suffolk?
No, we don't, but we have the data that David Meyer obviously assumed the DAs were going to provide once they clicked on that final field.
So what additional data do you say these parties owe you?
I'm not sure exactly what they have produced because I haven't seen it, but I believe what they have produced will permit the trial court's IT people to get us docket numbers and therefore dispositional data.
I think what the IT has done, I mean, Suffolk and Essex have provided a lot of information, but for every docket number that Essex or Suffolk was able to provide from the Meyer list, the IT department has been able to locate a fair amount of information about cases and dispositions and charges, which is about to get transmitted.
So we anticipate on remand we will eventually be able to actually identify Dukin defendants and see whether they want the assistance of counsel. And if so, seek to advise them whether doing so, proceeding, is a mistake or not. And this goes to the exposure cap issue, which from a systemic point of view, I think is CPCS's most urgent issue before the court. The Commonwealth repeatedly talks about how these Dukin defendants are trying to repudiate their plea bargains. Well, it's true. In the ordinary course, a defendant who truly repudiates a plea bargain goes back to square one. The slate is wiped clean. That's the Therian case, which is cited in both the Commonwealth's brief and the petitioner's brief. But to call these Dukin defendants individuals who are seeking to repudiate a plea bargain requires ignoring the systemic due process violation that brings them or would bring them to court in the first place. I would bring the court's attention to a case that is cited in the Commonwealth's brief at page 45, which is not cited in the other briefs, called, it's an appeals court decision from April, Gaston, 86 Mass Appeals Court 568. And in that case, the appeals court held that it was error for the judge to have denied a Dukin defendant's motion for a new trial after a jury trial where Dukin had tested the drugs. It seems to me settled law that at Mr. Gaston's further proceedings, the Commonwealth would be prohibited by due process from upping the ante. That's Blackledge versus Perry. And in the event of a conviction after a retrial, absent intervening misconduct, the defendant could not, could not be punished more severely.
But don't those cases depend upon the fact that there had been a previous trial as opposed to a plea?
Well, no, I don't think so. But
weren't they the facts of those cases?
Yeah, the facts involve trials.
And the Supreme Court has limited that to that context. At least the presumption of vindictiveness, for sure.
They're involving trials, but we are not talking about regular bargain for pleas, which a defendant, if he decides to repudiate, takes his chances. The real question, it seems to me, is why the Commonwealth should be permitted to proceed in a manner that violates due process simply because it used tainted evidence to coerce, Scott says, an involuntary guilty plea rather than to obtain a tainted verdict after trial. So there are other reasons that I'll rest on the brief as to why the court should exercise its supervisory power in what this is clearly the most significant systemic problem in our experience. I would just end by referring the court to a New Jersey case, Gookins, which involves the fraudulent evidence in a tiny number of cases compared to what we have here. And the court there said that those convictions needed to be vacated flat out because they are a stain on our judicial system and they mock the ideal of justice under law. So here we are, 2.5 years out, and the stain has not dissipated.
Thank you.
Good morning, Your Honors. May it please the Court, Vincent Moore on behalf of the District Attorney for the Suffolk District. And with me today is Mr. Quentin Weld on behalf of the District Attorney for the Eastern District. We're asking this Court do three things. Firstly, to deny the petitioner's request for a conclusive presumption of vindictiveness where revival of the charges previously dismissed in consideration of a change of plea.
Well, I take it the request isn't, it's take the word vindictiveness out of this. You just say you shouldn't have, for whatever you want to call it, you shouldn't have the things that were dismissed or whatever kept off the table.
Yes, in short.
In other words, be restored to the status or to the circumstances before there was a plea.
Correct. The parties would be returned. Well, yes, in short, yes. And just to clarify one matter just as we move forward, I'll be addressing the capping issue as well as CPCS's motion to intervene. Mr. Weld will address the balance of the claims.
Let's talk about the capping issue.
Sure.
This is different from most motions for new trial, in that it's a motion for new trial based on what this court has already found to be egregious government misconduct. Aren't you, as a DA, weren't you better off for the fact that that egregious misconduct was not known at the time of the plea? I mean, if the person had known of that at the time of the plea, the decision of that individual would be, should I go to trial, having spent no time in jail, putting aside whether he's been held pending trial, I'll throw the dice, and if I lose, I may get a mandatory, but if I win, I get no time in jail. Now, but of course, he did not know that the government's case was going to be markedly weakened by the Dukin misconduct. So he went for a plea because he thought the government's case was stronger than it was. He's already served his time, and now his calculus is different. Now it's not, if he throws the dice and moves for a new trial, he's already served his 2 or 3 years. The government's already gotten the sentence which is thought to be appropriate at the time of the plea, but now he's looking at the possibility of more time. Is that a fair thing for a defendant to have to do when part of the reason that he pled guilty was that there was concealment, not because of any prosecutive misconduct, I'm not claiming that, but because of misconduct at the Hinton lab?
Short answer is yes. And the reason for that is that we create these presumptions, or we when we cap, right, as we see in the other contexts, we do so because we're seeking to assure a defendant, right, that he will not be suffering a retaliatory act by the government. So, in essence, the point of the presumptions is to stop the government from punishing the exercise of a constitutional or statutory right. In this case, the right to file a motion to withdraw a guilty plea. The factual genesis of this particular claim happens to be misconduct, but misconduct alone is not the operative fact, because the misconduct, a finding of misconduct, as we have conclusively in these cases, does not compel the motion for new trial to be granted, because there still needs to be linked with materiality. Right. And that's exactly the same situation in the context of a Padilla claim, for instance, where a finding of ineffective assistance of counsel, absent a finding of materiality, does not compel the motion to be allowed. So where there's parity procedurally between those, I would suggest the remedies, which I think this court, from what I've heard, is essentially acknowledged that the remedy, that the revival of the charges occurring sort of as in the natural course of things, should occur.
But in Padilla, you're not better off. I mean, in Padilla, it was not your problem. It was not you did not cause the defendant to not get his immigration advice.
But it's certainly a different cause of action.
But here it was, again, not the prosecutors, but it was the government misconduct, which meant that the defendant did not know that the government's case was markedly weaker and may even be non-existent at the time of the plea. I mean, that's what makes these cases different from Padilla.
Well, I'd suggest it makes it different in the sense that the factual genesis of the claim is different, but at the end of the day, they both come to the same conclusion, which is that there's a due process violation.
But the difference is, you got everybody, at the time of the plea, everybody was operating with the same knowledge base, that is the prosecutors and the defense counsel, and everybody thought, here's a drug cert, looks like the stuff is cocaine, all right, we're going to offer this plea, you negotiate, you get a plea. Everybody's satisfied. Mm-hmm. Now, it turns out, so everybody was operating that was a good cert. Now it turns out it wasn't a good cert, and the reason it wasn't a good cert was because the Department of Public Health's chemist was dishonest, et cetera, and behaved egregiously.
And we have a conclusive presumption that was established in Scott that gives the defendant the benefit for the context.
But so now you come back, so you've gotten the plea this is what Chief Justice Gantz was saying, you've gotten the plea that the government thought was a fair plea, you come back, you get through the motion for new trial, and all of a sudden you get the fair plea plus Why is that fair? Why should it be on the back of the defendant?
I wouldn't characterize it as being on the back of the defendant. The defendant has withdrawn his consideration, which is his change of plea. And all of our case law strongly suggests that when the defendant withdraws his consideration,
But they're not with government misconduct as the reason.
Well, I don't think, I'd suggest that the factual genesis of the claim for the motion to vacate the plea isn't material, because that's not, the defendant's due process rights vis-a-vis that have been addressed in Scott. And he was given a conclusive presumption of misconduct where the defendant gets the benefit of what is essentially a legal fiction to satisfy that very heavy burden to show that misconduct actually occurred in his case.
Well, isn't the question whether Scott was an adequate remedy?
That is one way to frame the question, yes. And I would strongly suggest that Scott is an adequate remedy.
Well, I mean, I don't think that this question was before us at the time of Scott about what was going to happen in terms of the Commonwealth deciding that, the
exposure?
The exposure would be this. I don't think that that was a subject that we were really dealing with at the time. The question really is whether or not the solution in Scott is an adequate and just remedy for egregious governmental misconduct.
Yes, I mean, certainly the exposure issue was not one that was discussed in Scott. I would agree with that. And I think one important distinction to make here when we talk about the upping the ante and the additional, quote-unquote, additional exposure, that this isn't a case where the government has had a motion for new trial granted against it, so to speak, just to use that parlance. And now the defendant, who was originally charged as a second and subsequent, that the government is seeking a superseding indictment, charging him with some amplified charge. He is in exactly the same position with respect to the charging instruments, with respect to the charges, as he was on the morning of his plea.
Except
But the one disadvantage that he's holding right now, or I should say that you're holding over him, is that he's already served some time. And he when he starts thinking, and when the prosecutor starts thinking about, what are the risks that are involved if I win the case, if I lose the case, what are the strengths of my case? One of the things that the prosecution has in its quiver is that the defendant has a lot more to lose now if he goes to trial, because he's already served some time. He could get additional time.
Well, I would disagree. He has exactly the same amount to lose as he did on the morning of his plea originally. That top number, that exposure number, has not changed. That is, his number today, so to speak, is the same number on the day that his indictment was returned.
Except that if he wins, he would serve no time.
Right.
I'm sorry?
What's changed is not the amount he has to lose. What's changed is the amount he has to gain.
I would also disagree with that, because he's always had the opportunity to pursue a trial. And I think an important fact to remember here as well, in terms of whether or not, one of the arguments we make here is that this is not a ripe claim. And setting aside the details of that, in order for a defendant to prevail on his Scott claim, he has to demonstrate that, knowing what he knows today, he would have insisted upon going to trial and facing exactly the charges that he's now claiming makes him too scared to bring his motion for new trial. It is a factual impossibility for an individual who is actually chilled to win a motion for a new trial under the Scott rubric.
Not true at all. I mean, he could have said, I would have gone to. He has to, in order to prevail on a Scott claim, he has to say, if I had known that at the time, I would have gone to trial. That meant I would have thrown the dice.
Yes, facing.
And now he's saying, but now you're putting him in a position. But then he had more to gain. He had the opportunity of not going to jail. Now he's already been in jail. He may even have completed his sentence. That's what's different.
But the fact that he has jail credits doesn't impact that determination of whether or not he would have insisted upon going to trial knowing what he knows today.
If we don't agree with you, is there any way, to use the golf metaphor, that we can have a handicap for the Commonwealth other than a cap?
So is there any way in which the government can be punished further? Is that the question?
Yes. Well, is there any way that we can level the playing field to take into consideration the fact that the defendant has lost something, assuming that we don't agree with
Sure.
you?
Well, the defendant will have, in the interim, the defendant has now received the benefit of what I would suggest is candidly more favorable suppression law, which he'll be able to take advantage of in his subsequent retrial. He has more favorable statutory schemes with respect to minimum mandatories. Weights have increased for trafficking, and the school zone statute has really been materially changed. Many of these charges, frankly, can't be revived because the statutes have changed in the meantime. I think there's been substantial changes that have inured to the benefit of the defendant, should a defendant be pushing forward. And I'll also note that if these defendants are capped, they'll also ultimately be they'll be placed in a better position than a defendant who always insisted that he was not guilty and was simply pending trial when the misconduct was revealed. Because that individual has no charge concessions to which he can be capped.
Why do you say the government's going to be punished? The government, by its nature, obtained the plea that it thought to be an appropriate sentence for that person.
That's just the way I understood the question, in sense of that what additional sanction because essentially the way it would work is what additional, if it's a handicap, right, in what ways can
But the handicap would be to limit you to the sentence that you thought to be appropriate at the time that you thought the drug cert was a proper drug cert.
I am obviously not a golfer, so I have perhaps
not
misunderstood
either,
the
so I'm a
metaphor.
little confused.
It's not a golf metaphor.
Well, I think a handicap is. I just misunderstood the metaphor.
Okay. Well, put aside golf. The issue is, at the time of the plea, the Commonwealth, in the vast majority of these cases, basically said, we think this is an appropriate sentence.
Yes.
We think this is an appropriate time. Why is it punishment to limit you to that?
Well, because the defendant has withdrawn the consideration that led us to believe that's an appropriate sentence.
An appropriate time, an appropriate sentence in light of the fact that the Commonwealth wouldn't have to go to trial and take its resources to do that and move cases along. There's lots of reasons, lots of benefits to the Commonwealth in that
Exactly.
respect. And they're all gone.
Yeah, and the other benefit the defendant does have, and I apologize, I know I'm way over my time. The other benefit the defendant does have if he gets a trial and moves forward now and insists upon a trial, is he also gets the benefit of being able to adduce all of this evidence with respect to the Hinton lab at that subsequent trial. And empirically, that has not worked out for these defendants. They have almost overwhelmingly been convicted when they've gone to trial using that defense. But that is certainly available to them. And also, just as a factual matter.
So in those cases, when you go to trial, you establish the drugs through other means than the cert.
A retest.
You retest.
Yes, the
So
drugs.
you're really not in the same position you were back then. You get a whole new way of presenting the case because then you check out the bad stuff and have the new stuff. That's essentially not stuck with what you actually had. So you're not really back in the same position as you would be if you had to go back and try it based on the Duke and cert. And then you say, well, that would be the same position.
The position is the same insofar as
what you were relying on, which was flawed.
Well, which we've presumed to be flawed for the purpose of the motion.
And then you
to
would
vacate.
learn that it was flawed.
I mean,
that would really be putting you back.
If we were forced to use Annie Dukin as our witness, I suppose that's one way to look at it.
It's just a different way from the way you're looking at it, which presumes you could start all over again as though nothing had happened to the defendant in the meantime.
Well, if it was the case, the defendants would be precluded from adducing any evidence about the Hinton laboratory at all, including what are fairly vicious attacks on chain of custody, then yes, I would agree would be.
No,
would
I'm
be in a
not
better
saying that
position.
at all.
But no, but I think that's an important part of what the defense would allow. But in any event, if the court has no further questions, I recognize I'm far over time, and I apologize.
No need to. We gave you that time.
Good morning, Your Honors, and may it please the Court. Quentin Weld on behalf of the District Attorney for the Eastern District. I intend during my time to address largely the issue of undue delay, although I feel compelled at this point to say a few things about the exposure issue. To hear the arguments we just did, you would imagine that every single Dukin defendant who has successfully withdrawn a plea has been retried and, in the case of conviction, sentenced to a higher sentence than he received upon his plea. In fact, there are around, don't quote me on the exact number, but around 12 or so cases scheduled for retrial following the withdrawal of a plea. There has been one reconviction, Angel Rodriguez in my county, in Essex County. And there are a few notable things about that case. One of them is that upon the defendant's withdrawal of his plea, he was offered time served. And he decided to not take time served and proceed to trial. The jury, the new tribunal, heard evidence of the misconduct. They convicted him of the offenses on the original restored indictment, and the district attorney at that point had a conviction on these charges and recommended the sentence that she thought was commensurate with those convictions. This is not...
Time served, though, but there'd still be a conviction for the drug charge?
There would, but the idea that everything is, back up to the original point right after the plea is withdrawn is just not the case. It was offered in this case, and it was only after the reconviction that that sentence occurred. Anyway,
but the trial was not just. I mean, all of the original charges were tried.
Yes,
it went back to the higher trafficking.
It did.
Right?
It did.
Yeah.
On the issue of undue delay, Your Honors, this court has...
Let me just ask you, in the Rodriguez case, had the Commonwealth agreed to dismiss any charges as part of the plea? And now, as a result of the reinstatement of the proceedings, it got convictions on charges that otherwise but previously had been dismissed.
It was actually a trafficking weight that was at issue.
Okay.
It was trafficking over 100 grams and then over, I believe it's 25, but that was the drop down. It wasn't actually a separate charge that was dismissed, but it was that level. Mm-hmm. With regard to the argument of undue delay, this court has already implemented procedures and presumptions for the benefit of Dukin defendants. And they have led to these special sessions that have been created, presided over by retired Superior Court justices, by which Dukin defendants can seek relief, and they have been receiving a speedy adjudication of their claims.
That may be true for the claims that have been located and counsel assigned, but it seems to me there is an issue, though, of some large number of people. I mean, I'm going to assume that many defendants who fit within the Dukin, a Dukin defendant as Mr. Keene has defined it, have no idea that Annie Dukin was the primary or secondary chemist who signed the drug cert in his or her case. And so there's a lot of people out there who would have no idea that there are, Superior Court judges who are sitting there waiting to hear their cases. I mean, they wouldn't know they had a case.
There's several things that belie a belief that there is a large mass of people who are unaware of a potential claim that they may have. The first thing I'll say is that the two offices who are respondents in this case, Suffolk and Essex, over the summer, with Your Honor's aid, were able to identify close to, I believe, 17,000 docket numbers with Social Security's dates of birth, all the information necessary to identify a defendant. This was provided to the committee. So,
but very belatedly, I might add.
But that's not true of the other six. No, and I appreciate the enormous number of hours that you both have spent. I'm not saying anything, but you've done that, and I'm going to assume that you as you've said, that you combed to be able to do that. There are 6 other offices out there that have not done that.
Sure. My reason for saying it, Your Honor, is perhaps different from what you might have expected. My reason for citing that 17,000 cases that were given to the committee is that one would imagine that once those people were identified and notified by CPCS, whose notification efforts are ongoing, that there would be some sort of uptick in the number of motions filed in the sessions, in the special sessions.
I'm not sure that's fair because I would guess, I don't know, you could ask, but it seems to me people in these cases have been waiting to see what the trial court would come up with.
By the logic of the undue delay argument with respect to the notification issue, it seems the only way the petitioners would be satisfied is if every single person who could potentially be affected by the misconduct came forward and filed a motion. The numbers they cite, as an aside, are very inflated. They are the district attorneys, after all the work we have done on the Meyer list and our own databases, estimate that it is more in the neighborhood of 20,000 or so. It's still a large number of cases, but it doesn't makes sense to expect everyone to come forward and make a claim, especially as Justice Bina was saying earlier, that there are people who would rightly believe that the misconduct was not material to their plea.
Can I ask you, I guess I can since I'm Chief Justice, imagine you had a situation in which you discovered that a police officer had planted drugs 5 years ago. Investigation of that police officer revealed it. Police officer was prosecuted. Would the DA's office have an obligation to inform those individuals who had been convicted based on that police officer's conduct that perhaps there was exculpatory information that they should be aware of?
So the case Commonwealth versus Waters, I believe, which dealt with an officer's misconduct, that was more about whether people on whose case he had worked were entitled to a presumption of misconduct, and they were not in that case. But there was no mention of such a notification obligation. Again, it perhaps wasn't directly at issue, but that it seems to me that there would not be an actual notice requirement for the reason that such notice is effectively impossible and rarely required under the law in any area, civil or criminal.
So you're saying that there is no duty of a prosecutor to provide exculpatory information after conviction? Is that your position?
Well, that is the Brady law, Your Honor, which I think is not on point with these circumstances. The remedy that is in place for these defendants, the modified Rule 30 procedure, is there in the foreseeable future. It will be there.
But only if they know it's there. Only if they know it's there. I mean, aren't we talking at cross purposes here? I mean, people don't necessarily know that Annie Dukin was the chemist in their case. So unless they're somehow notified of that, how do they know that they even have the possibility of bringing a Rule 30 motion?
Your Honor, as we were preparing for this argument, we thought of ways that could potentially be used to essentially affect that notice, like in some sort of way that would be to what you are speaking of, Justice Link. And one possibility is all of the defendants ever convicted of a 94C violation.
No, how about linking to the police reports, you know, that was just done but I mean, it's done in the summer of 2014. That's kind of late to have been doing this. And it just seems that, you know, when that information was uniquely available to the district attorneys, it should have been provided long before that.
Your Honor, it was our position that it was not uniquely available to the district attorneys.
Well, and why would that be?
Because their docket numbers and case information are possessed by both sides of a given criminal case. CPCS would have had this information in their files.
But they say they don't have the information and that they notify the district attorneys of that fact. And
Justice Link, it's notable that there has not been an affidavit to the effect that the committee has examined their own databases to find this information. I don't think it's particularly significant because the parties have been working together to assemble as good a list as possible of all of these people, and we have a very good list. We have 17,000 names of people who could be notified starting right now and are being notified as we speak. And the fact of the matter is the procedures already in place are sufficient to meet the needs of people bringing such claims. And that's essentially our response to the delay argument.
Your time is up, but there's one matter we haven't discussed, and I'd like to ask you. Is there any reason why we should not apply the principle in Simmons to the Scott hearings and say that you can ask whatever you want to ask of a defendant, but if he goes to trial, it can be used against him only to impeach him if he were to testify?
The position of the district attorneys is that is at least a reasonable application. We do not argue strongly against that circumstance.
Okay. Thank you.
Thank you.